Real estate boundary lines and property line disputes are some of the most wicked disputes in real estate. And 40 years of ownership and 35 years of brokerage, I've seen a lot of different stuff, a lot of fences in the wrong place, all sorts of stuff. And so today with me I've got Stephen Gaynor, real estate attorney, and he's going to explain a lot of things. I'm going to ask him questions, and he's going to give us answers and tips and stuff that most of us wouldn't even dream of asking. So, Stephen, why are these boundary lines just so nasty?
Well, for one thing, there's a hidden motive that's usually going on. And the hidden motive is you've got two neighbors who live together, and often there are all things about them that have created friction. One person, one neighbor didn't invite the other to their son's graduation or wedding, and the other, they don't like the other person's dog for whatever reason. And so these hidden things often aggravate the actual boundary disputes and make it even worse. So that what might be overlooked in one case makes people even more angry. Of course, the sad thing about neighbors and boundary disputes is if you have a divorce, one spouse can move away and does move away to another city, another state. But with a neighbor dispute, for the next 30 years, you may be picking up the paper every morning and seeing the other person outside. So it really becomes kind of a certain human tragedy when these horrible fights happen.
What kind of disputes do you run into? Like, I hear the word prescriptive easement, and I think about that, and it sounds like someone's claiming the use of someone's property line, like at a lot that was getting built, and the neighbors were claiming the path across the corner. They're claiming prescriptive easement, and it seemed like the law just allows that if you steal the property long enough, you can have it legally. I mean, just give me some examples or some. What are all the issues?
Well, that's a good question, and what law students learn is that the way in America and England property is looked at is really as kind of a pail of marbles, each one being a little right. So that when you own a piece of property, you own all the marbles. The right to cross your property, the right to plant trees there, the right to farm, even maybe the right to dig for oil and gas. These are all the rights you have. And that's important to keep that in mind when you talk about this, because there are two things happening when you talk about sort of the squatter's rights. In some cases, someone is saying, I now own all those marbles in terms of part of your land. Sometimes what they're saying is, hey, I now just own a few of those marbles. I've got a right to build a driveway here over the corner of your lot. I've got this or that. And that comes up. Now, the interesting thing is that all of this, it's really hard to understand because it really looks like authorized theft. But it came up because hundreds of years ago, English courts saw a certain goal that they had to have. You had an awful lot of very wealthy landowners in England, and they never used their land. They'd go off to Europe on long trips to France or Italy, and there was the land. Meanwhile, there were people who wanted to use that land. And the English courts began to say, well, it's incredible to have all this lack of productivity, not using the land when someone could use it. So they began to create rules because they were so anxious not to have total waste. And the basic rule they created, either for someone owning the land, claiming to own the land outright, or claiming to own a few of the marbles or littler rights, the basic rule was these people had to get onto the land and very clearly be on it, using it. Number two, so that it was open to anyone paying attention, including the landowner, that they were there. Number two, they had to do this for 5 years. And number three, the landowner hadn't given them permission to do that. So now you have the things in common that these two kinds of squatters' rights have. Where they then differ is that if the person grabbing the land paid the property tax on that land, then a court after 5 years would say you have all the marbles, you own that land. If they didn't pay the property taxes, the court would merely say, well, you have the number of marbles you've been using. Since you've been crossing that land all the time, now you have a right to cross it in that position. So that's why this came up. And so what appears to be outrageous theft had a kind of a social pattern. That's changing today, and it's interesting because California courts are saying we don't have aristocrats with hundreds and hundreds of acres not using their land, and land-hungry peasants right outside the boundary. We've got a bunch of suburban neighbors, and each of them owns a house. And one neighbor says, "Gee, I want to plant tulips on your land," or "Why can't I put a driveway on your land?" So the courts are now much more strict about allowing that, and they're tending more and more to say, "We're not sure we're going to give you," particularly when it comes to the right of way. "We're not sure how much we're going to give you on that. We're not sure how much notice you gave." So that's changing a lot because courts finally face the fact that the society has changed. And it's a bunch of suburban people fighting over rose bushes or something like that. And so that's been a big issue. Another one people you have is simply confusion about the boundary line. When you talk about a boundary line, you're having two people saying one of us owns all the marbles to this piece of land, and the boundary's in the wrong place. If the boundary is shoved over against my neighbor's property, then my neighbor now has less claim. That piece of land where the line is moved over, that neighbor now has none of the marbles.
So I'm seeing that a lot with like fences. Fences were put on a property line, give or take, maybe 100 years ago in some places around Marin County. And that maybe at some time they discover the fence is off a foot or two here and there. They shake hands, don't worry about it. Then the neighbor sells the house and new neighbors come in, now they want to build, and they want to build a bigger house. That extra foot or two makes a difference.
That's right, and that of course brings us to, how can you head off these problems? And I know a responsible broker like you, and you mentioned this and I was impressed, you can suggest to a buyer that when they get the insurance that guarantees the ownership going all the way back, they do more than that, and they get insurance in which a surveyor walks the land and the title company says, "This is exactly what you own."
That's another good point. The difference between a survey and a record of survey. Survey topo mat is just the lines on the map, but the record survey actually pins the points.
Yeah, all a title company does, unless you buy this extra insurance, say, "We don't know quite where the line is, but we know going back 100 years that somebody first had this land, maybe from a wealthy Spaniard coming up from Mexico, and we know how it was transferred, but we don't know quite what part of the land was transferred." So for that extra payment of a premium, you can get boundary insurance, and that is a good way to go very often between people in a suburb. Now, if it's a new subdivision, you may not need it because the developer presumably had licensed surveyors doing this. But when you're looking at some hilly parts of Marin, no one ever did this. The older areas.
Actually, I thought that too, but just recently came across one where people were selling their house to put up a fence to increase. It was a corner lot, so they put up a fence to increase their side yard, adding value, right? Well, just literally an hour after the property hit the market, they get a letter from the neighbor saying, "Hey, you put your fence in the wrong place. You better move it, or we're going to sue you."
Good grounds for having gotten that insurance in the first place. But the other issue, which brings up a side issue, is another major reason why these things come up, is because you have two neighbors who've been together for 35 years, and it's nice neighbor, nice neighbor. They like each other. Let's just let things go. Let's not worry. And where I have been a lawyer in a lot of lawsuits is one of those nice neighbors moves and sells, and the person buying it is not that nice. And they're suddenly saying, "Wait a second, why is your fence on my land? I've done a survey." And so the fight starts.
Yeah, my generosity is not for sale to the next buyer, right?
Why are you putting your flowers there? They don't belong there.
That wasn't that a good story? Your story with flowers on the hillside.
Yeah, I had clients who had a very nice neighbor, much older than them, and she loved the fact that they were going to plant flowers on the hillside. It wasn't clear. Well, it was pretty clear that a large part of the hillside belonged to this nice older lady, but she didn't care. She just kind of said, "Go ahead and plant flowers there. I like them." And my clients look out their kitchen window on these beautiful flowers. Now, when the older lady moved and sold to these other people, they said, "Hey, wait a second. We don't want your flowers on our hillside." You got to move them. And I think if anybody's listening, one of the issues right away is that the older lady had given permission on the flowers, which right away may mean there's no buildup of a squatter's right. But anyway, my clients went to court with these other people. It was a big fight, tens of thousands of dollars on this issue. A better way to have handled that for my clients would have been to go to this lady and say, can we pay you for the right to have flowers here? And that would be an easement, but it would be an easement by contract.
So Steve, I think we've thrown a lot of issues on the table, but the solutions kind of seem to be worse than the problems. A lot of times you get a letter from the attorney, another gets his attorney, and off they go to the races, and you find out the cost of solving the thing was much worse than it was to just solve it really quick up front. So how do you, what are some answers to prevent just suffering from this stuff?
Well, you know, it's true, and I think a lot of lawyers get into these things, and I don't always, from a lot of lawyers I know, I don't think they're trying to play a game to make a lot of money, but they have great egos, and they all want to be right. The solution I usually use is to be very firm but direct with the other side, let them know, and really let my client know what this can cost, and the chances of winning, because these are never sure things, and then try to work something out without getting, everybody at this point is pretty angry at each other. But the question is, how do you tamp that down enough so you try to work something out? Get a negotiation. And so I've had a lot of lawsuits in this area, many of which I've won and some of which I've lost. But if you can get people to finally sit down and try to compromise on some way, that's the best thing. And that'll cost, you know, a quarter or a fifth of what it's going to cost to go through a full-blown trial. And trials are never certain. And good judges will tell you that they don't know ahead of time what they're going to rule on. So I try to do that. I think I line up all my clients' guns. I assume the other lawyer, if they're like me, lines up all the other side's guns. And then we say, maybe we ought to talk, because the two parties can blow themselves out of the water. They can both spend so much money, there's nothing left. And that's what I try to do. And very often that works. Again, not offending the other side, but letting them know that we can be very tough and we're sure they can be very tough. That's a style I use in a lot of areas in my business law practice and my real estate law practice. So, and I'm happy to talk to people briefly if they want to call me. Give my phone number. Should I give my phone number?
How do they contact you?
Yeah, I work a lot up in Nevada or San Francisco, and the rest of Marin, and the phone number is 415-892-7214, and I have a website. My last name is like Gaining Speed, Gainer, Gainer, and the website is gainerlaw.com. So people can find out more about me on the website or contact me.
Steve, that was great. I learned a lot. Just
Good.
And so it was worth just sitting here. So I'm really happy.
Thank you.
Thanks for watching.